You are watching PR English Shorthand Dictations YouTube channel.
This is English shorthand dictation number 376 and the dictation speed is 100 words per minute. Ready? Start. This court has held that from the mere fact of suicide within 7 years of marriage, one should not jump to the conclusion of abetment unless cruelty was proved. The court has the discretion to raise or not to raise the presumption because of the words may presume. It must take into account all the circumstances of the case, which is an additional safeguard. In the absence of any cogent evidence of harassment or cruelty, an accused cannot be held guilty for the offense under section 306 of Indian Penal Code by raising presumption under section 113A. Before we part with this matter, we may only observe that the criminal justice system of ours can itself be a punishment. It is exactly what has happened in this case. It did not take more than 10 minutes for this court to arrive at an inevitable conclusion that the conviction of the appellant convict for the offense punishable under section 306 of the Indian Penal Code is not sustainable in law. The ordeal for the appellant started sometime in 1993 and is coming to the end in 2024, almost after a period of 30 years of suffering. At the same time, we are also mindful of the fact that a young woman died, leaving behind her 6 months old infant. No crime should go unpunished. But at the same time, the guilt of the accused has to be determined in accordance with law. To put it in other words, the guilt of the accused has to be determined on the basis of legal evidence on record. The question is why and where did the two courts falter? In our opinion, the two courts faltered as they failed to apply the correct principles of law to the evidence on record on the subject of abatement of suicide. The two courts get enamored by just three things. First, the deceased committed suicide within 7 years of marriage. Second, the accused was demanding money from the parents of the deceased for starting some business. And third, the deceased used to remain tense. We do not say that these are irrelevant considerations. All the three aspects are relevant, but there are settled principles of law to be made applicable to the matters of the present type. In the case of accusation for abetment of suicide, the court should look for cogent and convincing proof of the act of incitement to the commission of suicide, and such an offending action should be proximate to the time of occurrence. Appreciation of evidence in criminal matters is a tough task, and when it comes to appreciating the evidence in cases of abetment of suicide punishable under section 306 of the Indian Penal Code, it is more arduous. The court must remain very careful and vigilant in applying the correct principles of law governing the subject of abatement of suicide while appreciating the evidence on record. Otherwise, it may give an impression that the conviction is not legal but rather moral. For all the above reasons, we have arrived at the conclusion that the prosecution has not been able to establish the guilt of the accused beyond reasonable doubt. In the result, the appeal succeeds and is hereby allowed. The judgment and the order of conviction passed by the trial court, as affirmed by the High Court, is hereby set aside. Having heard the learned counsel appearing on behalf of the state and the learned senior advocate appearing on behalf of the respondent accused, and having gone through the impugned judgment and order passed by the High Court, more particularly the observations made in paragraph 42, we are of the opinion that the observations made by the High Court in paragraph 42 are absolutely unwarranted and against the judicial discipline and propriety. When this court earlier confirmed the conviction of the accused for the offences under section 302 Indian Penal Code, and that too after hearing learned senior advocate appearing on behalf of the accused. Thereafter, it was not open for the High Court to make comments upon the investigation and on merits of the case. The High Court also ought not to have made observations in paragraph 42 that certain aspects were not brought to the notice of this court and no assistance was provided to the accused to prefer an appeal before this court, and that the conviction was upheld without hearing the side of the accused respondent herein. However, it is required to be noted that when this court passed the order remanding the matter for sentence and confirmed the conviction, this court heard the learned senior advocate appearing on behalf of the accused. Therefore, the High Court is not right, even factually, in observing that this court confirmed the conviction without hearing the side of the accused on merits. Judicial discipline requires that once the conviction was confirmed by this court, that too after hearing the accused, the High Court should not have thereafter made any comment on the merits of the case, more particularly when the conviction was specifically confirmed by this court and the matter was remitted to the High Court only for the purpose of considering the sentence, namely whether death penalty or life sentence or any other appropriate sentence. Even the learned senior advocate appearing on behalf of the accused in the present case has also fairly considered and stated that the observations made in paragraph 42 are absolutely unwarranted and are unsustainable. Leaving the matter there, we set aside the observations made by the High Court made in paragraph 42 of the impugned judgment and order. Now, so far as the impugned judgment and order passed by the High Court commuting the death penalty to life imprisonment is concerned, we see no reason to interfere with the same, more particularly when the High Court, after considering the aggravating and mitigating circumstances, has commuted the death penalty to life imprisonment.